Attorney Terrence Bradley testifying at Fani Willis hearing. Part 3.
Mr. Bradley, I showed you 2 text messages, correct? Both of those text messages occurred on January the 5th of 2024 at approximately 11:56 a.m. Am I correct?
I think so, yes.
Okay. And the text messages would have been between you and Miss Merchant, correct?
I didn't see it. Yes, it should be.
Okay. And I've shown the same 2 to prosecution, so we're talking about the same 2. In the text message to Miss Merchant, you indicated knowledge of some activity on the part of Mr. Wade, correct? I haven't asked him anything about what the
flag for the court. This is a topic and a specific exchange that Ms. Merchant went into, and there were objections that were sustained.
All right, understood.
Yes.
And it's your testimony that the information that you imparted to Ms. Merchant in these 2 text messages is based entirely on confidential communications between you and Mr. Wade, correct?
Objection. He's referencing specific knowledge. The specific knowledge comes from Mr. Wade regarding establishing privilege.
One other question. He didn't get anything. He just said, are these 2 text messages about privileged communications? Actually, he's testing you. I don't see an issue there.
Yes.
And is it your testimony that the knowledge that you have, which you imparted in these 2 text messages, came from Mr. Wade and Mr. Wade alone?
Yes.
Is that correct?
Yes.
Can you tell us when it was that Mr. Wade imparted this information to you?
Objection.
All right. And I think
that's what you're going to do.
Sure. So he wants to stand down on privilege.
And I'm going to introduce for the record when we finish these 2 text messages so that Your Honor has those back there so that you can.
Sure. What would it be marked as?
Video. Go ahead. Once I put a staple in it, I think it'll be Defense Exhibit 26.
Alright, so this is marked and on the record it's Defense Exhibit 26, but not necessarily for its.
This is not an evidentiary questions. This is for purposes of the court conducting the in-camera review. Put a staple in it just to make sure that you see it.
No, straight. Alright, so now what else?
So, there was also reference, if I remember correctly, to some email correspondence in which Ms. Merchant sent you the motion that she was going to file to disqualify Ms. Willis and Mr. Wade for your review. Is that correct?
That's correct.
Okay. And that was sent to you in an email?
That was correct.
And did you respond to it in an email?
I don't think I responded to her email.
Actually, no. You responded by text. I'm sorry, I mischaracterized it. You responded by text?
If I can look at my text, I can. But I'm assuming I did, but.
Okay, I'm going to get it for you because I don't want there to be any assumption. Let me show you. I'm going to show you if I might approach you. I made reference to an email Ms. Merchant would have sent you about the motion she was going to file. If you look at this, this appears to be the email that you received. It's dated January the 6th, 2024, 10:20, like 10:25 a.m.
Yeah, I see it. Okay, email, yes.
So that's the email that you received, correct? Along with it, obviously, the attachment, which is referenced.
Yes.
Then, did you respond to that email within the text message that I just pushed you?
Yes, I said it looks good.
So the answer is yes.
Oh, yes, I did. Okay.
I'm going to mark this as another exhibit for your honor to look at. Since you look like I have seen it. Okay, I'm going to have these marked as 27. Okay? All right, so is it your position that what is reflected when we hand it to you? Okay. What is the course rule to ask about?
I will take it case by case. I think he's doing all right, so we'll need to ask for this witness.
Is it your position that your response, which is the second page of Defense Exhibit 27, is based on confidential communications that you had with Mr. Wade?
Do you want me to read the response?
No, I'm only asking you whether or not the response, you actually already said what it said. I don't want you to read it again. Is that response, based on confidential communications that you had with Mr. Wade? Objection, this is privileged again.
All right, so now we're talking about the email, potentially referencing the motion as a whole. He hasn't been asked to actually confirm or deny any specifics, just to say whether his response is privileged. So I think we're just laying the foundation, just like we did with the text message. So you can answer that question, sir.
Was my response privileged?
Was your response to the email of Ms. Merchant, which is on page 1 of that exhibit, is your response, which is on page 2, is that based on knowledge that you received from Mr. Wade pursuant to confidential communications?
Yes.
Have you discussed with the district attorney's office this case, the purported testimony?
Of my testimony?
Yes.
No.
At all?
No.
No prep, no conversations, no nothing?
No.
Have you given your attorneys, for this matter, did you give them permission to speak with the district attorney's office?
He asserted his own privilege, but that's not crazy.
Objection to be heard? Absolutely. This is broken. Sustained. Next question. Do you know what attorneys share privileged information with the district attorney's office?
No, I don't know what my attorney shared or didn't share. I don't know if they even met.
Last question. Have you spoken to Mr. Wade prior to today? No, actually, withdraw that. You're no longer in the same partnership or fee-sharing arrangement with Mr. Wade, correct?
That's correct.
When did you leave that fee-sharing partnership, pseudo-partnership arrangement?
I don't remember the hard date, but maybe sometime like July, August of 2022, I think.
Okay. And what was the reason for the partnership or the fee-sharing arrangements, what caused the separation?
I wanted to leave and go out on my own.
And that's the only reason.
I wanted to leave and go out on my own. Yes.
I understand, but that was the only reason. There wasn't any suggestions or allegations of any form of misconduct on either part, either on your part or Mr. Wade's part, correct?
Misconduct of what?
I'm trying not to get into specifics. Is there any allegations made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Made of suspected misconduct on your part or on Mr. Wade's part? That's a fairly simple question. Did you accuse him of doing anything? Without getting into what it is, were there any accusations made by you or him against each other?
We had a disagreement, yes.
And had that disagreement have anything to do with Miss Willis?
Oh, no.
Okay. Did it have anything to do with your conduct?
No.
Did it have anything to do with his conduct?
Hold on, wait. So, we had a disagreement. Whether the disagreement was... We disagreed. And so we dissolved. Well, I left the firm.
And was the disagreement having anything to do with alleged or supposed misconduct by either one of you?
If you define misconduct, I'm telling you we had a disagreement and we...
Just tell me what the disagreement was.
The disagreement is mine to know. I mean, I don't see the relevance of the disagreement that I had. It had nothing to do with this Trump case or any other case.
I'm simply getting a question asked, what was the disagreement? It's not privileged, correct?
No, that is privileged.
Oh, it is privileged. Why is that privileged?
Because it's privileged. I can tell the court in camera, but it was privileged.
Ask a few questions further to see if this is actually something that does fall within that privilege. We can take it from there.
Did it have anything to do with you representing Mr. Wade in any capacity? Excuse me.
It would fall in that line, yes.
But your testimony is that it has nothing to do with your representation of Mr. Wade in connection with Miss Willis.
As in a connection to Miss Willis, that's correct.
Connected to the matter for which you were hired by Mr. Wade?
I wasn't hired by Mr. Wade.
I thought you were the attorney representing him in the divorce.
Oh, I apologize. I thought you were saying something else. Oh, yes. So will it apply as to whether I was hired during the... Yes, that's correct.
I'm not sure what this correct means under that. We kind of got lost on it.
Yes,
It did or did not relate to your representation.
It did relate to my representation.
In the marriage case.
It does.
And this was whose decision was it? At that point, did you stop representing Mr. Wade?
It wasn't at that point, no.
Was it before that?
No, it was after that.
Okay. And how much longer did you represent Mr. Wade in the divorce action?
I like to see the divorce proceeding to see Mr. Wade. I represented Mr. Wade for a time after that. He represented me in a construction case for a time after that. And I'll have to look at the filings. I ended up hiring new counsel for my construction case. He ended up, but it wasn't right at that moment. It wasn't in a matter of weeks. It was...
So you continued representing him in connection with the divorce case after you had the separation that you've made reference to.
And he continued to, yes, and he continued to represent me on a construction case.
But the separation, at least in part, if I heard you correctly, and please tell me if I'm wrong, had something to do with your representation of him in the divorce case.
That is correct.
Now, Mr. Wade has testified that he did not have a relationship, personal relationship, or romantic relationship with Miss Willis until sometime early 2022. Okay? I'm believing that is the premise of what I'm about to ask you. Do you possess information that counters that, that's inconsistent with that?
Any information Mr. Bradley has would be privileged, Your Honor.
Okay, let's say no. I think we...
Would such information be privileged? in your mind?
I think this has already been asked during Ms. Merchant's direct, so we're covering the same ground. I'll sustain that.
So, I can't get an answer to whether he possesses information which is inconsistent without getting into the information itself.
I think the issue would be that we've already gotten an answer on that. Now we're asking the same question again. Ms. Merchant asked a variation of that, and we already answered.
I think the variation Your Honor is referencing whether or not he had what would be personal information, independent source information. Mine is not so limited. Mine is, I'm asking him point blank whether or not he has information from whatever source, including Mr. Wade, that is inconsistent with Mr. Wade's testimony.
Mr. Wade is privileged communication. So therefore the answer is it's privileged. If it excluded Mr. Wade, that would be a different appropriate question.
And I just want to say, the answer is either it came from privileged information or it's hearsay. That's it. He's already testified that he has no personal knowledge.
Unless it's for impeachment at this point. But, Mr. Senator, I think that might be too fine a distinction for me to see the need for the question. I think I'm failing to see the difference.
Well, I'm not asking, respectfully, I'm not asking you to see the difference. I'm asking whether I can ask that question and elicit a response which doesn't elicit the actual communications, which is what I'm attempting to do. And if Your Honor says I can't, then I'm finished.
And I think that this was another aspect of what came up before, which is, in my mind, even confirming the existence of the information goes into privileged communications, whether he does or does not possess information. If it came from that relationship, that's part of the privilege as well. So if I make that clear, then
So you're sustaining what the objection would be.
That's right. It'd be sustained on privilege.
And of course, all the questions that we're talking about as far as the foundation about when things are said and what is said, you're going to go into, if I understood correctly, ex parte in camera with the two exhibits we talked about.
That's right. My intent would be to make a record of the knowledge of when it was attained and the extent of it in the different sources, and that'll be sealed.
And what was actually said.
That's right.
So I guess my question before I sit down is, if hypothetically you learn through this in-camera ex parte examination that the information that this gentleman has through the attorney-client privilege is in fact inconsistent with what Mr. Wade testified to under oath, then the court is going to then make a determination of whether it can be used here or whether it just remains in the record, sealed.
So my intent would be to make the distinction of, from the in-camera hearing, if I still determine that everything is covered by privilege, then anything else that is said cannot go into the factual determinations or credible determinations that need to be made. And so just the issue of whether the privilege did or did not exist is preserved.
So, again, just to follow through to make sure. So, if the court knows that there's been a fraud upon the court through the lie of Mr. Wade, none of us are going to know that that in fact occurred, and the court's going to be in a position of making a determination on the motion, even though the court knows that it doesn't have all the information, truthful information.
I'll take a closer look at the case law you provided to see if that is actually a variation of the crime fraud exception. And I'll apply the crime fraud exception as I see it.
Right. And again, I'm not suggesting it is a variation. It is totally separate from crime fraud. It has nothing to do with using the legal advice of the attorney in order to commit a crime. It's you go ahead and commit fraud or lie to the court when you fully know that someone, your attorney, has information which is counter or inconsistent with what you've testified.
And to that, Mr. Sadoff, that is something that you can, I've got this case from Ohio, but if you can find something more on point for Georgia before we schedule
Other
this
than the one I gave you,
the
1935 case.
The Atlanta Bottling Company, I don't think it went that far. I think it just kind of said the sword and shield language, and it didn't go so far as to say there's this alternative theory about fraud upon the court, but we can flush that out in our research.
I appreciate it. Thank you.
Mr. Stockton.
No question, Joe.
Mr. Durham.
No question, Your Honor.
Mr. McDougald.
No question, Your Honor.
Mr. Rice.
Good question, Your Honor.
Mr. Bradley, you were counsel for Mr. Wade in the divorce case when the interrogatories were initially served on opposing counsel on or about December 27th of 2021, correct?
That's correct.
And you were also counsel on him when the amended interrogatories were served on May 30th of 2023, correct?
That's incorrect.
So you ceased representing him sometime before May 30th of 2023.
That's correct.
At any point during the divorce proceedings, was a pleading filed with the court or a paper served on opposing counsel that purported to have your signature that you were not the one that signed or authorized your signature on?
Say that again?
Did anyone sign your signature without your authorization on any pleading or any other paperwork served on opposing counsel in the divorce proceeding?
I don't think so. If you have the documents, I can authenticate my signature.
And you have testified that you also practice criminal law and divorce law and perhaps other types of law as well.
That's correct.
And are you aware that OCG 16-6-19 defines adultery as a misdemeanor crime in the state of Georgia?
If you say so, yes, sir. Go ahead.
Judge, I would ask the court to take judicial notice of that.
For what relevance?
Judge, I think it does go directly to the crime fraud exception. Because before we draw objection, because if Mr. Wade was providing information to his counsel about his intent to either commit adultery or that he was committing adultery, then that would be a misdemeanor crime. It would implicate the crime fraud exception. And additionally, as we know from yesterday's evidence,
Isn't adultery, as a statute, just on its face, been found unconstitutional? You can't actually charge anyone with adultery anymore.
It is still current.
Then it can't be a crime.
It is still a current charge.
Let's move on to that next argument.
Additionally, Judge, with regard to the interrogatories, we have 3 different sets of interrogatories that were filed that came into evidence yesterday, 21, May of 23, December of 23, that contain false information. We also have the January of 24 that contains the invocation of privilege. So to the extent this witness has information, both with the original interrogatories that were filed in December of 2021, and frankly with regard to the later ones, even though he wasn't counsel, that would be a false swearing and fraud on the court, which again is a criminal offense, and therefore the crime fraud exception would apply as well.
Okay. Understood.
No further questions.
Okay, Mr. Gillen.
That was the end of part 3 of attorney Terrence Bradley testifying at Fani Willis hearing. If I didn't know better, I would think he was on trial by the way they are questioning him and looking into his own personal life. As you leave the page, don't forget to hit the like bell and subscribe to the channel if you haven't done so as yet. Thank you for watching.